Question 1. Governance review demonstrates that a real estate agent in the Northern Territory is considering implementing a new cloud-based transaction management software to streamline their operations. This software promises enhanced collaboration, document storage, and automated workflow tracking. However, the agent is concerned about client data privacy and the potential for unauthorized access. What is the most ethically sound and legally compliant approach for the agent to adopt when introducing this new software to ongoing and future property transactions in the Northern Territory? Option A. Proceed with using the transaction management software for all transactions, assuming that standard cloud security measures are sufficient and that clients will implicitly agree to its use by engaging the agent's services. Option B. Implement the transaction management software immediately for all new transactions, providing a brief overview of its existence to clients via email, without specifically detailing security measures or seeking explicit consent for its use. Option C. Continue to rely exclusively on manual, paper-based record-keeping and communication methods for all transactions to completely eliminate any potential digital security risks, even if it significantly slows down the process. Option D. Inform all parties involved in a transaction, buyers, sellers, other agents, about the use of the transaction management software, detailing its security protocols, and obtaining their explicit consent before sharing any sensitive information through the platform. The correct answer is D. Inform all parties involved in a transaction, buyers, sellers, other agents, about the use of the transaction management software, detailing its security protocols, and obtaining their explicit consent before sharing any sensitive information through the platform. Explanation. This scenario presents a professional challenge due to the inherent tension between leveraging technological tools for efficiency and maintaining client confidentiality and data integrity, particularly within the Northern Territory's real estate regulatory landscape. The agent must navigate the ethical imperative to protect client information, while also utilizing modern software to manage transactions effectively. Careful judgment is required to ensure compliance with the Northern Territory's Property Law Act 1974 and relevant Australian consumer protection laws, which mandate honesty, transparency, and the safeguarding of sensitive client data. The best approach involves a proactive and transparent communication strategy. This includes clearly informing all parties involved in a transaction about the specific software being used for transaction management, outlining the security measures in place, and obtaining explicit consent for the use of this technology. This aligns with the ethical obligations of real estate agents in the Northern Territory to act in the best interests of their clients and to maintain professional standards. By being upfront about the tools and their security, the agent fosters trust and ensures all parties understand how their information is being handled, thereby adhering to principles of informed consent and data protection. An approach that involves using a transaction management system without disclosing its use to all parties is ethically flawed. This lack of transparency can lead to a breach of trust and potentially violate consumer protection principles that require clear and honest dealings. Furthermore, if the software is not adequately secured, it could lead to a data breach, exposing sensitive client information and resulting in significant legal and reputational damage, contravening the duty of care owed to clients. Another unacceptable approach is to rely solely on manual, paper-based systems to avoid any perceived data security risks associated with software. While this might seem like a safer option, it can lead to inefficiency, increased risk of human error, and delays in transaction processing. In today's market, failing to adopt reasonably secure and efficient technological tools can be seen as a failure to provide a competent and modern service, potentially impacting client satisfaction and the agent's professional standing. The Northern Territory's regulatory environment encourages the use of appropriate tools to facilitate efficient and professional service delivery, provided ethical and legal standards are met. Finally, adopting a new transaction management system without adequate training or understanding of its security features is also professionally unsound. This can lead to accidental data exposure or misuse of client information, even with good intentions. Professionals have a duty to ensure they are competent in using the tools they employ, and that these tools are configured and used in a manner that protects client data, in line with the expectations set by the Northern Territory's regulatory framework. Question 2. Operational review demonstrates that a real estate agent in the Northern Territory is advising a client on purchasing a property. The client has expressed confusion regarding the different ways ownership can be structured. The agent needs to explain the implications of fee simple, leasehold, joint tenancy, and tenancy in common as they apply to Northern Territory property law. Which of the following approaches best reflects the agent's professional responsibility? Option A. Provide a general overview of ownership types, highlighting that joint tenancy typically involves survivorship and tenancy in common allows for separate shares, without specific reference to Northern Territory law. Option B. Clearly explain the distinct legal characteristics and implications of fee simple, leasehold, joint tenancy, and tenancy in common, referencing how these apply under Northern Territory legislation and common law principles governing property ownership. Option C. Explain that tenancy in common is the most common form of ownership and that the client should automatically assume this structure unless otherwise specified. Option D. Advise the client that leasehold is essentially the same as fee simple, as both grant the right to occupy the property and focus on the purchase price. Correct answer is B. Clearly explain the distinct legal characteristics and implications of fee simple, leasehold, joint tenancy, and tenancy in common, referencing how these apply under Northern Territory legislation and common law principles governing property ownership. Explanation. This scenario presents a professional challenge due to the potential for misrepresentation of ownership interests, which can lead to significant legal disputes and financial repercussions for all parties involved. Navigating the nuances of different ownership types in Northern Territory real estate requires a thorough understanding of the Land Title Act 2000 NT and common law principles governing property ownership. Careful judgment is required to ensure accurate advice is provided to clients, upholding professional integrity and client best interests. The correct approach involves clearly and accurately advising the client on the implications of each ownership type, specifically distinguishing between fee simple, leasehold, joint tenancy, and tenancy in common, as they apply to the Northern Territory context. This includes explaining that fee simple represents the highest form of ownership, leasehold involves a right to occupy for a defined period, joint tenancy includes the right of survivorship, and tenancy in common allows for distinct shares and independent disposition of those shares. Providing this detailed, jurisdiction-specific advice ensures the client makes an informed decision based on their specific circumstances and legal rights under Northern Territory law. This aligns with the ethical duty of care and competence expected of real estate professionals, requiring them to possess and apply knowledge of relevant legislation. An incorrect approach would be to provide generic advice without referencing the specific legal framework of the Northern Territory. This fails to acknowledge that property law, including ownership structures, is jurisdiction-specific. For instance, simply stating that joint tenancy includes survivorship without contextualizing it within the Northern Territory's legal framework might overlook specific statutory provisions or common law interpretations that could apply. Another incorrect approach would be to conflate leasehold with fee simple ownership, as these represent fundamentally different rights and durations of possession and control under Northern Territory law. Failing to distinguish between the right to occupy for term leasehold and outright ownership, fee simple, is a significant error. Furthermore, advising on tenancy in common without explaining the implications for inheritance and the ability to sell or gift one's share independently of other co-owners would be incomplete and potentially misleading, as these are key distinguishing features of this ownership type under Northern Territory law. Professionals should adopt a decision-making process that prioritizes understanding the client's objectives, identifying the relevant legal jurisdiction, in this case, the Northern Territory, and then applying the specific laws and principles governing property ownership within that jurisdiction. This involves consulting relevant legislation, such as the Land Title Act 2000 NT, and understanding established legal precedents. Accurate and comprehensive advice, tailored to the client's situation and the specific legal context, is paramount to fulfilling professional obligations and avoiding ethical breaches. Question 3. Operational review demonstrates that a valuer in the Northern Territory, NT, is tasked with determining the market value of a well-established, multi-tenanted retail complex. Considering the specific characteristics of the NT property market and the nature of the asset, which valuation methodology would best reflect current market realities and provide the most defensible valuation? Option A. Hybrid approach combining elements of all three methods equally, without prioritizing the method most reflective of current market transactions. Option B. Cost approach, by estimating the cost to replace the existing structure and deducting an allowance for obsolescence and physical deterioration. Option C. Income approach, by projecting future rental income and applying a capitalization rate derived from general commercial property yields. Option D. Comparative market analysis, by examining recent sales of similar retail properties in comparable NT locations and adjusting for differences. The correct answer is D. Comparative market analysis, by examining recent sales of similar retail properties in comparable NT locations and adjusting for differences. Explanation. Scenario analysis. This scenario presents a professional challenge for a valuer in the Northern Territory, NT, due to the inherent subjectivity in property valuation and the need to adhere to specific regulatory requirements and ethical standards. The valuer must select the most appropriate valuation method for a unique commercial property, considering its specific characteristics and market conditions in the NT. Failure to do so can lead to inaccurate valuations, potential financial loss for clients, and breaches of professional conduct under the Northern Territory Property Act and relevant industry standards. The challenge lies in balancing the theoretical strengths of each valuation method with the practical realities of the NT market and the specific nature of the property. Correct approach analysis. The most appropriate approach in this scenario is the comparative market analysis. This method involves comparing the subject property to similar, recently sold properties in the same or a comparable market area within the Northern Territory. Adjustments are made for differences in features, condition, location, and other relevant factors. This approach is correct because it directly reflects current market sentiment and buyer behavior in the NT. The Northern Territory Property Act, while not dictating specific valuation methodologies, implicitly requires valuations to be realistic and reflective of market value. Industry best practices, as often guided by professional bodies like the Australian Property Institute, API, emphasize the comparative market analysis as the primary method for residential and many commercial properties where sufficient comparable sales data exists. It is grounded in observable market transactions, making it the most reliable indicator of what a willing buyer would pay in the NT market at a given time. Incorrect approach is analysis. The income approach, which derives value from the property's potential to generate income, is less suitable as the primary method here. While applicable to income-producing properties, its effectiveness is heavily reliant on accurate and reliable income data, including rental rates, vacancy rates, and operating expenses specific to the NT commercial property market. If this data is scarce, outdated, or subject to significant fluctuation, the income approach can produce a less reliable valuation. Ethically, relying on speculative income projections without robust supporting data would be unprofessional. The cost approach, which estimates the cost to replace or reproduce the property, less depreciation, is also less appropriate as the primary method for this type of commercial property. This method is generally best suited for newer, purpose-built properties or unique structures where comparable sales data is scarce. For an established commercial property, estimating accrued depreciation accurately can be highly subjective and challenging, potentially leading to an over- or undervaluation. Furthermore, the cost of construction in the NT can be influenced by unique logistical and environmental factors, making it difficult to establish a reliable replacement cost without extensive research, which may not accurately reflect market value. Relying solely on this method without considering market realities would be a failure to provide a valuation that truly reflects what the property would command in the NT market. Professional reasoning. Professionals should adopt a hierarchical approach to valuation, starting with the method that best reflects current market conditions and available data. In the Northern Territory, for a commercial property where comparable sales are likely available, the comparative market analysis should be the initial and primary consideration. If this method presents limitations due to data scarcity or unique property characteristics, then the income approach or cost approach may be considered as supplementary or alternative methods, but only after a thorough assessment of their applicability and the reliability of the data required for each. Professional judgment involves critically evaluating the strengths and weaknesses of each method in the context of the specific property and the NT market, and clearly documenting the rationale for the chosen methodology and any adjustments made. Adherence to the Northern Territory Property Act and professional standards ensures that the valuation is defensible and serves the client's best interests. Question 4. The risk matrix highlights a potential issue with an unregistered easement affecting a property in Darwin, Northern Territory. The vendor is unaware of its legal standing. What is the most appropriate course of action for the real estate agent to recommend to the vendor? Option A. Proceed with marketing the property as is, assuming the unregistered easement has no legal effect and will not impact the sale. Option B. Advise the vendor to obtain independent legal advice to clarify the validity and implications of the unregistered easement before proceeding with marketing or sale. Option C. The agent should research the Land Title Act 2000 to determine the legal enforceability of the unregistered easement and advise the vendor accordingly. Option D. Recommend the vendor remove any physical evidence of the easement from the property to avoid buyer concerns. Correct answer is B. Advise the vendor to obtain independent legal advice to clarify the validity and implications of the unregistered easement before proceeding with marketing or sale. Explanation. The risk matrix shows a potential for disputes arising from unregistered easements impacting a property's marketability in the Northern Territory. This scenario is professionally challenging because it requires a real estate agent to navigate complex property law principles, specifically concerning the creation, recognition, and impact of unregistered interests in land, and to advise clients appropriately without providing legal advice. Careful judgment is required to balance the agent's duty to their client with the limitations of their professional scope. The best approach involves identifying the potential unregistered easement, understanding its implications for the property's title and value, and advising the vendor to seek independent legal advice to clarify the easement's validity and scope. This approach is correct because it directly addresses the identified risk by recommending a course of action that seeks legal certainty. Under the Northern Territory's Land Title Act 2000, while registered interests are paramount, unregistered interests can, in certain circumstances, be recognized and enforced, particularly if the purchaser has notice of them. Advising the vendor to obtain legal advice ensures that the nature and enforceability of the unregistered easement are properly assessed by a qualified legal professional, which is crucial for accurate disclosure and for determining the property's true market value and saleability. This aligns with the agent's ethical duty to act honestly and with due diligence, and to avoid misrepresentation. An incorrect approach would be to ignore the unregistered easement, assuming it has no legal standing simply because it is not registered. This fails to acknowledge the potential for unregistered interests to create legal rights and encumbrances, which could lead to significant legal disputes and financial losses for the purchaser, and expose the agent to liability for misleading or deceptive conduct under consumer protection laws. It also breaches the agent's duty to disclose all material facts that could affect the property's value or desirability. Another incorrect approach would be for the agent to attempt to interpret the legal validity and enforceability of the unregistered easement themselves. This constitutes providing legal advice, which is outside the scope of a real estate agent's license and expertise. Doing so could lead to incorrect advice, potentially causing harm to the client, and exposing the agent to professional misconduct proceedings and legal repercussions. A further incorrect approach would be to advise the vendor to simply remove any evidence of the potential easement from the property or its documentation. This is unethical and potentially fraudulent, as it involves concealing a material fact that could affect the property's title and value. Such an action would be a clear breach of disclosure obligations and could lead to severe penalties. Professionals should adopt a decision-making framework that prioritizes risk identification, client education, and referral to appropriate experts. This involves 1. Identifying potential issues like unregistered easements through due diligence and risk assessment. 2. Understanding the potential implications of these issues for the transaction. 3. Clearly communicating the identified risks to the client. 4. Recommending that the client seek independent professional advice, legal, in this case, to resolve the issue. 5. Acting only within the bounds of their professional competence and license. Question 5. The efficiency study reveals a common scenario in Northern Territory real estate transactions, where a purchaser indicates they have secured pre-approval for finance from a mortgage broker. What is the most prudent and legally compliant approach for a real estate agent to manage this situation to ensure a smooth and lawful sale process in the Northern Territory? Option A. Advise the purchaser to proceed with the sale based on the mortgage broker's informal assurance that the loan will be approved, without requiring formal documentation. Option B. Request written confirmation of the pre-approval from the purchaser, detailing the loan amount, terms, and the name of the lending institution, and ensure the mortgage broker provides the purchaser with a formal loan offer or disclosure statement compliant with the National Credit Code before the contract becomes unconditional. Option C. Accept the purchaser's verbal assurance of pre-approved finance from their mortgage broker and proceed with the sale, assuming the broker's recommendation is sufficient. Option D. Encourage the purchaser to use a friend or acquaintance who claims to have good connections with lenders to arrange their finance, bypassing formal mortgage brokers. The correct answer is B. Request written confirmation of the pre-approval from the purchaser, detailing the loan amount, terms, and the name of the lending institution, and ensure the mortgage broker provides the purchaser with a formal loan offer or disclosure statement compliant with the National Credit Code before the contract becomes unconditional. Explanation. The efficiency study reveals a common challenge in Northern Territory real estate financing, balancing the need for timely property transactions with the imperative to protect consumers from predatory lending practices and ensure the integrity of the financing process. This scenario is professionally challenging because it requires a nuanced understanding of the Northern Territory's specific legislative framework governing mortgages and property sales, particularly the Consumer Credit Code, CCC, as applied in the NT, and the duties of real estate agents and mortgage brokers. Careful judgment is required to navigate the potential conflicts between a vendor's desire for a quick sale and a purchaser's need for adequate financial due diligence and protection. The best professional approach involves proactively ensuring that all financing arrangements are clearly documented and compliant with the Northern Territory's Consumer Credit Code. This means verifying that any loan offered to a purchaser meets the disclosure requirements, responsible lending obligations, and any specific cooling-off periods or rights mandated by NT law for consumer credit. It also entails ensuring that the real estate agent acts within their statutory duties, which include not misleading parties about financing or making representations that could be construed as financial advice unless appropriately licensed. This approach prioritizes legal compliance and consumer protection, thereby mitigating risks for all parties involved and upholding professional standards. An approach that involves accepting a purchaser's verbal assurance of pre-approved finance without seeking written confirmation or verifying the terms of that finance is professionally unacceptable. This fails to meet the responsible lending obligations under the Consumer Credit Code, which require lenders to assess a borrower's suitability for a loan. It also exposes the vendor to the risk of a failed sale due to the purchaser ultimately being unable to secure the necessary funds, and potentially breaches the real estate agent's duty to act with due diligence and not misrepresent the likelihood of finance being approved. Another professionally unacceptable approach is to proceed with the sale based on a mortgage broker's informal assurance that the loan will be approved, without ensuring the broker has provided the purchaser with a formal loan offer or disclosure statement that complies with the National Credit Code, which applies in the NT. This bypasses crucial consumer protection mechanisms designed to ensure borrowers understand the terms, costs, and risks of their loan. It also places undue reliance on the broker's opinion rather than on legally mandated documentation. Finally, advising a purchaser to use a non-licensed individual to arrange their finance, even if they claim to have a good relationship with lenders, is a significant regulatory and ethical failure. This circumvents the licensing and regulatory oversight required for financial services in Australia, including the Northern Territory, under the National Credit Code and ASIC regulations. It exposes the purchaser to potential fraud, misrepresentation, and non-compliant loan products, and breaches the real estate agent's duty to only engage with licensed professionals. Professionals should adopt a decision-making framework that prioritizes regulatory compliance and ethical conduct. This involves 1. Identifying all applicable legislation, e.g., the Northern Territory's Consumer Credit Code, National Credit Code, and relevant real estate agent legislation. 2. Proactively seeking and verifying all necessary documentation related to financing, rather than relying on verbal assurances. 3. Understanding the specific duties and limitations of their role, e.g., A real estate agent cannot provide financial advice. 4. Consulting with legal or financial professionals when uncertainty arises. 5. Always acting in the best interests of their client while upholding the integrity of the transaction and protecting consumers. Question 6. The monitoring system demonstrates that a real estate agent in the Northern Territory has provided a new tenant with a property condition report that is incomplete, with several sections left blank, and has not yet allowed the tenant to add their own comments or observations. Which of the following actions best reflects compliance with Northern Territory residential tenancy laws? Option A. Proceed with the tenancy using the incomplete report, assuming the tenant will raise any issues they find with the property. Option B. Provide the tenant with the partially completed report and inform them that they can add any missing details themselves at a later stage. Option C. Advise the tenant that the report will be completed within the first week of their tenancy and that they can add comments then. Option D. Immediately cease providing the incomplete report and arrange for a full and accurate property condition report to be completed and provided to the tenant for review and comment before they take possession of the property. Correct answer is D. Immediately cease providing the incomplete report and arrange for a full and accurate property condition report to be completed and provided to the tenant for review and comment before they take possession of the property. Explanation. The monitoring system demonstrates a potential breach of the Northern Territory's Residential Tenancies Act 1999, NT, and associated regulations concerning property condition reports. This scenario is professionally challenging because it requires a real estate agent to balance the immediate needs of a new tenant with the legal obligations owed to both the tenant and the landlord, ensuring transparency and adherence to statutory requirements. The agent must act with integrity and diligence to avoid potential disputes and penalties. The correct approach involves the agent ensuring that a comprehensive and accurate property condition report is completed and provided to the tenant before or at the time of the tenant taking possession of the property. This report must detail the condition of the premises and any inclusions at the commencement of the tenancy. Providing the tenant with a copy of this report and allowing them a reasonable period to review and add their own comments before signing is a fundamental requirement under the Residential Tenancies Act 1999, NT. This proactive measure protects both parties by establishing a clear record of the property's condition, thereby preventing future disagreements regarding damage or wear and tear. It directly aligns with the Act's intent to promote fair and transparent tenancy agreements. An incorrect approach would be to provide the tenant with a partially completed report, or a report that is not thoroughly detailed, with the intention of completing it later. This fails to meet the statutory requirement of providing a complete and accurate report at the commencement of the tenancy. It creates an unfair advantage for the landlord and leaves the tenant vulnerable to claims for pre-existing damage. Another incorrect approach is to provide the tenant with the report only after they have occupied the property for a significant period. This contravenes the spirit and letter of the law, which mandates that the report be provided at the outset of the tenancy to allow the tenant to verify its contents from the beginning. Failing to allow the tenant to add their own comments to the report before signing is also a significant breach, as it denies them the opportunity to document their observations and protect their interests. Professionals should adopt a systematic approach. Always prioritize statutory compliance. Before any tenancy commences, ensure all required documentation, such as the property condition report, is fully and accurately completed. Educate yourself and your team on the specific requirements of the Residential Tenancies Act 1999, NT, and relevant regulations. Maintain clear communication with both landlords and tenants, setting expectations regarding the property condition reporting process. Document all interactions and provide copies of all relevant documents to all parties involved. Question 7. Strategic planning requires a mortgage broker in the Northern Territory to carefully consider a client's request for an interest-only mortgage. Given the client's stated desire for lower initial repayments, which of the following approaches best demonstrates professional diligence and adherence to responsible lending principles in the NT? Option A. Immediately approve the interest-only mortgage as requested, as the client has explicitly stated their preference for lower initial payments. Option B. Focus on securing the loan product that offers the highest commission for the brokerage, ensuring the client meets the basic eligibility criteria for an interest-only loan. Option C. Conduct a comprehensive financial needs assessment. Clearly explain the risks and long-term implications of an interest-only mortgage, including the need for a principal repayment strategy, and explore alternative loan structures that align with the client's overall financial well-being. Option D. Advise the client that interest-only mortgages are generally not recommended and steer them towards a standard principal and interest loan without further discussion of their specific needs. The correct answer is C. Conduct a comprehensive financial needs assessment. Clearly explain the risks and long-term implications of an interest-only mortgage, including the need for a principal repayment strategy, and explore alternative loan structures that align with the client's overall financial well-being. Explanation. Scenario analysis. This scenario presents a professional challenge for a mortgage broker in the Northern Territory, NT, because it requires them to balance the client's immediate financial desires with their long-term financial well-being and regulatory obligations. The client's request for an interest-only mortgage, while potentially attractive for short-term cash flow, carries significant risks that must be thoroughly explained and considered. Broker's duty of care in the NT extends beyond simply facilitating a loan. It involves providing advice that is suitable and in the client's best interests, adhering to the principles of responsible lending and consumer protection under relevant NT legislation and national frameworks like the National Credit Code. Failure to adequately assess and disclose risks can lead to financial harm for the client and regulatory repercussions for the broker. Correct approach analysis. The best professional practice involves a comprehensive assessment of the client's financial situation, goals, and risk tolerance, followed by a detailed explanation of the implications of an interest-only mortgage. This approach prioritizes the client's long-term financial health and aligns with the principles of responsible lending. The broker must clearly articulate that an interest-only loan means the principal amount remains unchanged, and therefore, the client will not build equity in the property through repayments. They must also explain the risks associated with potential interest rate rises on an adjustable rate interest-only mortgage, the potential for negative equity if property values decline, and the critical need for a clear repayment strategy for the principal at the end of the interest-only period. This aligns with the broker's obligation to act in the client's best interests and provide suitable advice, as mandated by consumer protection laws and industry codes of conduct in the NT. Incorrect approaches analysis. Proceeding with the interest-only mortgage without a thorough assessment of the client's capacity to repay the principal at the end of the term, or without adequately explaining the risks, constitutes a failure to act in the client's best interests. This could lead to the client being unable to meet their obligations, potentially facing foreclosure, and suffering significant financial detriment. Such an approach would likely breach responsible lending obligations, which require lenders and brokers to take reasonable steps to ensure a loan is not unsuitable for the borrower. Another incorrect approach would be to immediately dismiss the interest-only option without exploring its suitability or offering alternatives. While caution is warranted, a broker's role is to advise and guide, not to unilaterally decide for the client. Failing to explore the client's motivations for seeking an interest-only loan and offering alternative solutions that might better meet their needs, such as a longer fixed-rate term or a different repayment structure, would be a disservice. Finally, focusing solely on securing the loan with the highest commission, regardless of the client's long-term financial implications, is unethical and a clear breach of professional duty. This prioritizes the broker's financial gain over the client's welfare, which is unacceptable under any regulatory framework governing financial advice and lending. Professional reasoning. Professionals in the NT mortgage market should adopt a client-centric decision-making process. This involves 1. Active listening to understand the client's stated needs and underlying motivations. 2. Conducting a thorough financial needs analysis, including income, expenses, assets, liabilities, and future financial projections. 3. Educating the client about the various mortgage products available, including their features, benefits, risks, and suitability for different financial situations. 4. Clearly disclosing all associated costs, fees, and potential risks, particularly for non-traditional loan structures like interest-only mortgages. 5. Recommending products that are demonstrably suitable for the client's circumstances and goals, and documenting this advice. 6. Ensuring compliance with all relevant NT and Australian consumer credit legislation and industry best practices. Question 8. Quality control measures reveal that a real estate agent in the Northern Territory, NT, is representing a seller whose property has a history of termite infestation, which has reportedly been treated. The agent is aware of this history, but has not yet discussed the specifics with the seller. What is the most appropriate course of action for the agent to ensure compliance with NT real estate brokerage regulations and ethical best practices? Option A. Proactively seek detailed information from the seller regarding the nature and extent of the termite infestation and any remediation undertaken, then disclose this information to prospective buyers as required. Option B. Inform prospective buyers that the seller is handling the termite issue and avoid discussing it further. Option C. Assume the termite issue is minor and has been fully resolved, therefore no disclosure is necessary to prospective buyers. Option D. Disclose to prospective buyers that the property has a history of termites, but provide no further details about the infestation or treatment. The correct answer is A. Proactively seek detailed information from the seller regarding the nature and extent of the termite infestation and any remediation undertaken, then disclose this information to prospective buyers as required. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires a real estate agent in the Northern Territory, NT, to navigate the delicate balance between client confidentiality and the legal obligation to disclose material facts. Failing to properly disclose can lead to significant legal repercussions and damage to the agent's reputation, while oversharing could breach client trust. Careful judgment is required to determine what constitutes a material fact that must be disclosed under NT law. Correct approach analysis. The best professional practice involves the agent proactively seeking clarification from the seller regarding the nature and extent of the termite infestation and any remediation efforts. This approach is correct because it directly addresses the potential material fact without making assumptions. Under the Northern Territory's property regulations, agents have a duty to disclose material facts that could influence a buyer's decision. By engaging with the seller to obtain accurate information about the infestation and its resolution, the agent can then make an informed decision about what information needs to be disclosed to prospective buyers, ensuring compliance with their disclosure obligations and maintaining ethical standards. Incorrect approaches analysis. One incorrect approach is to assume the termite issue is minor and not disclose it, hoping it won't be discovered. This is a failure to comply with the property regulations, which mandate disclosure of material facts. A termite infestation, even if treated, can be a significant concern for buyers and is considered a material fact. Another incorrect approach is to disclose the existence of termites without providing any details about the extent of the infestation or the remediation undertaken. This partial disclosure can be misleading and still fail to meet the agent's obligation to provide sufficient information for a buyer to make an informed decision. It could also be perceived as an attempt to downplay a significant issue. Finally, an incorrect approach would be to refuse to discuss the termite issue with the seller and simply tell the buyer that the seller is handling it. This abdicates the agent's responsibility to ensure proper disclosure and could lead to the buyer feeling misled if the issue is more serious than initially communicated. Professional reasoning. Professionals should adopt a proactive and transparent approach. When a potential material fact arises, the first step is to gather all relevant information from the seller. This involves asking specific questions about the nature of the issue, its history, and any actions taken to address it. Once sufficient information is obtained, the agent must then assess whether this information constitutes a material fact under the relevant NT legislation. If it does, the agent must ensure this fact is clearly and accurately communicated to prospective buyers in writing, allowing them to make an informed decision. If there is any doubt about whether a fact is material, it is always best practice to err on the side of disclosure. Question 9. Quality control measures reveal that a licensed real estate agent operating in the Northern Territory, NT, is approaching their license renewal date and needs to ensure they have met their continuing professional development (CPD) obligations. Which of the following actions best demonstrates adherence to the licensing requirements and best practice for CPD in the NT? Option A. Assuming that the CPD requirements are the same as they were for the previous renewal period and completing a similar number of hours in general real estate industry training. Option B. Proactively consulting the official Northern Territory government website or contacting the relevant licensing authority to confirm the exact number of CPD hours required. the types of activities that qualify, and any specific reporting procedures for license renewal. Option C, relying on informal advice from a colleague about which training courses are generally accepted for CPD in the NT, without independently verifying their suitability. Option D, completing a broad range of real estate-related online courses and attending a few industry webinars in the weeks leading up to the renewal deadline, without confirming if these specific activities are recognized by the NT licensing authority. The correct answer is B, proactively consulting the official Northern Territory government website or contacting the relevant licensing authority to confirm the exact number of CPD hours required, the types of activities that qualify, and any specific reporting procedures for license renewal. Explanation. Scenario analysis. This scenario presents a professional challenge for a real estate agent in the Northern Territory, NT, concerning the renewal of their license. The core difficulty lies in accurately identifying and fulfilling the continuing professional development, CPD, requirements mandated by the NT regulatory framework. Failure to do so can lead to license suspension or cancellation, impacting their ability to practice and potentially causing reputational damage and financial loss. Careful judgment is required to ensure compliance with the specific, and sometimes nuanced, rules governing CPD in the NT. Correct approach analysis. The best professional practice involves proactively verifying the specific CPD requirements for license renewal directly with the Northern Territory government's relevant licensing authority, or by consulting the official NT legislation and guidelines. This approach ensures that the agent is aware of the exact number of hours, the types of activities that qualify as CPD, and any specific reporting obligations. This is correct because it directly addresses the regulatory mandate for license renewal, ensuring adherence to the Property Agents Administration Act 2008, NT, and its associated regulations, which stipulate CPD obligations for licensed agents. This proactive verification minimizes the risk of non-compliance. Incorrect approaches analysis. One incorrect approach is to rely on general knowledge or assumptions about CPD requirements from previous license renewals or from information shared by colleagues without independent verification. This is professionally unacceptable because CPD requirements can change over time, and relying on outdated or unconfirmed information can lead to a shortfall in required hours or the completion of non-qualifying activities, thus failing to meet the current regulatory standards set by the NT. Another incorrect approach is to assume that completing any real estate-related training or attending industry events automatically satisfies CPD obligations. This is professionally unacceptable because NT regulations likely specify approved CPD activities and may have limitations on the types of training that count towards the requirement. Without confirming the specific criteria, an agent might complete activities that are not recognized by the licensing authority, leading to non-compliance. A further incorrect approach is to only address CPD requirements at the last minute, just before the license renewal deadline. This is professionally unacceptable because it creates undue pressure and increases the likelihood of errors or omissions. It also prevents the agent from seeking clarification from the licensing authority if they encounter any ambiguities, potentially leading to a rushed and non-compliant submission. Professional reasoning. Professionals should adopt a proactive and diligent approach to license renewal. This involves maintaining a calendar of renewal dates, regularly reviewing regulatory updates from the NT licensing authority, and keeping meticulous records of all completed CPD activities. When in doubt, seeking direct clarification from the official regulatory body is paramount. This systematic approach ensures ongoing compliance and upholds professional integrity. Question 10. System analysis indicates that a real estate agent in Darwin, Northern Territory, has been approached by a seller to list their property. Subsequently, a potential buyer, who is already a client of the same agent, expresses interest in purchasing that specific property. The agent believes they can manage the transaction fairly for both parties. If the agent proceeds to represent both the seller and the buyer, what is the most appropriate and legally compliant course of action, considering the agent's commission is calculated as 2.5% of the sale price for the seller and a fixed fee of $5,000 from the buyer? Option A. Provide both the seller and the buyer with a full written disclosure of the dual agency situation, detailing the potential conflicts of interest and the agent's obligations to each party, and obtain their informed written consent before proceeding with the transaction. Option B. Advise the buyer that their interests will be secondary to the seller's, as the seller is the primary client who initiated the listing, and proceed with the transaction after informing the seller. Option C. Proceed with representing both parties, assuming that their existing professional relationship with the buyer and the agent's intention to be fair will suffice, without any formal disclosure or consent process. Option D. Inform both parties verbally about the dual agency, but proceed without obtaining written consent, relying on the verbal agreement to proceed. The correct answer is A. Provide both the seller and the buyer with a full written disclosure of the dual agency situation, detailing the potential conflicts of interest and the agent's obligations to each party, and obtain their informed written consent before proceeding with the transaction. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent conflict of interest that arises when an agent represents both the seller and the buyer in the same transaction. Navigating this situation requires a deep understanding of agency law in the Northern Territory, NT, specifically the duties owed to each party and the implications of dual agency. Mismanagement can lead to breaches of fiduciary duty, legal repercussions, and damage to professional reputation. The core challenge lies in ensuring that both parties receive independent and unbiased advice, which is difficult to achieve when the agent's commission is tied to the successful completion of the sale, potentially incentivizing favoritism. Correct approach analysis. The best professional practice in this scenario involves the agent clearly disclosing the potential conflict of interest to both the seller and the buyer in writing, as mandated by the Northern Territory's Property Agents Administration Act 2003 and its associated regulations. This disclosure must be comprehensive, explaining the nature of dual agency and the agent's obligations to each party. Crucially, the agent must obtain informed written consent from both the seller and the buyer before proceeding with the dual agency arrangement. This approach is correct because it prioritizes transparency and informed consent, upholding the ethical and legal obligations to act in the best interests of all parties, as far as is reasonably practicable, while acknowledging the inherent limitations of dual representation. It ensures that both parties are aware of the agent's dual role and have agreed to proceed under these conditions, thereby mitigating the risk of undisclosed conflicts. Incorrect approaches analysis. One incorrect approach is for the agent to proceed with representing both parties without any disclosure, assuming that their impartiality will suffice. This is a significant ethical and legal failure. The Property Agents Administration Act 2003 requires agents to disclose any potential conflicts of interest. Failing to do so breaches the duty of good faith and honesty owed to both the seller and the buyer, and can lead to disciplinary action, including fines and loss of license. Another incorrect approach is to disclose the dual agency verbally, but not obtain written consent. While verbal disclosure might seem like a step towards transparency, it lacks the legal weight and clarity required by NT regulations. Written consent provides irrefutable evidence that both parties understood and agreed to the dual agency, protecting both the agent and the clients. Without written consent, the agent cannot demonstrate compliance with their disclosure obligations, leaving them vulnerable to claims of misrepresentation or breach of duty. A further incorrect approach is to disclose the dual agency, but then prioritize the seller's interests exclusively, believing that the seller is the primary client. While the initial agency agreement might be with the seller, once dual agency is established and consented to, the agent owes fiduciary duties to both parties. Prioritizing one party over the other without explicit agreement or justification constitutes a breach of duty to the disadvantaged party and is contrary to the principles of fair dealing and the spirit of the NT's property agent legislation. Professional reasoning. Professionals in the Northern Territory must adopt a proactive and transparent approach to agency relationships. When faced with a potential dual agency situation, the decision-making process should begin with a thorough review of the Property Agents Administration Act 2003 and its regulations. The primary consideration should always be the client's best interests and the agent's fiduciary duties. If a dual agency situation arises, the agent must immediately identify the potential conflict. The next step is to assess whether informed consent can be obtained from both parties after full disclosure. If such consent cannot be obtained, or if the agent believes they cannot adequately represent both parties impartially, they should decline to act as a dual agent and advise the parties to seek independent representation. This rigorous adherence to disclosure and consent requirements, coupled with a commitment to impartiality, forms the bedrock of ethical and legally compliant real estate practice in the NT. Question 11. Quality control measures reveal that a real estate agent in the Northern Territory NT is advising an investor on financing options for a property acquisition. The investor is keen on a quick purchase and is considering both hard money loans and seller financing. What is the most professionally responsible approach for the agent to take in advising the investor on these financing methods? Option A. Suggests seller financing as a straightforward alternative, emphasizing the flexibility and ease of negotiation without detailing the importance of a formal loan agreement or independent legal review. Option B. Focus on the potential for rapid property acquisition through both financing methods, advising the investor to proceed quickly to secure the deal without extensive discussion of the associated financial risks. Option C. Provide a detailed explanation of the terms, interest rates, fees, repayment schedules, and potential consequences of default for both hard money loans and seller financing, strongly advising the investor to seek independent legal and financial advice before proceeding. Option D. Recommend hard money loans as the fastest way to secure funds, highlighting the speed of approval and closing without dwelling on the higher interest rates and shorter repayment terms. The correct answer is C. Provide a detailed explanation of the terms, interest rates, fees, repayment schedules, and potential consequences of default for both hard money loans and seller financing, strongly advising the investor to seek independent legal and financial advice before proceeding. Explanation. Scenario analysis. This scenario presents a professional challenge for a real estate agent in the Northern Territory, NT, because it involves advising an investor on financing options that carry significant risks. Hard money loans and seller financing, while potentially faster, often come with higher interest rates, shorter repayment terms, and less consumer protection compared to traditional mortgages. The agent must navigate these complexities while adhering to their fiduciary duties and the specific regulatory framework governing real estate professionals in the NT. Misrepresenting the risks or failing to adequately disclose them could lead to significant legal and ethical repercussions. Correct approach analysis. The best professional practice involves a comprehensive disclosure of all material terms and risks associated with both hard money loans and seller financing. This includes clearly outlining interest rates, fees, repayment schedules, potential for default, and the consequences of default, such as foreclosure. The agent should also advise the investor to seek independent legal and financial advice before committing to either financing option. This approach aligns with the principles of acting in the best interests of the client, providing full disclosure and avoiding misleading representations, as mandated by the Northern Territory's property laws and professional conduct guidelines for real estate agents. Incorrect approaches analysis. Recommending hard money loans solely based on their speed of access to funds, without thoroughly explaining the associated high costs and short repayment terms, constitutes a failure to act in the client's best interest and a potential misrepresentation of the risks. This overlooks the agent's duty to ensure the client understands the full implications of the financing. Suggesting seller financing as a simple alternative without detailing the potential for the seller to enforce the loan terms aggressively, or without advising the investor to obtain independent legal review of the agreement, fails to provide adequate protection for the investor and could lead to disputes or financial hardship. Focusing only on the potential for quick acquisition of property through seller financing, while downplaying the importance of a formal loan agreement and independent legal advice, neglects the agent's responsibility to ensure the transaction is conducted ethically and legally, and that the client is fully informed of all aspects of the agreement. Professional reasoning. Professionals should adopt a client-centric decision-making process that prioritizes transparency and informed consent. This involves 1. Understanding the client's financial situation and investment goals. 2. Thoroughly researching and understanding the intricacies of all proposed financing options, including their risks and benefits. 3. Providing clear, comprehensive, and unbiased information to the client, highlighting all material terms and potential downsides. 4. Strongly recommending that the client seek independent legal and financial advice to validate their understanding and decision. 5. Documenting all advice and disclosures provided to the client. Question 12. Strategic planning requires a real estate agent in the Northern Territory, NT, to advise a vendor on the most suitable listing agreement. The vendor has expressed a strong desire for their property to receive maximum marketing exposure and achieve the highest possible sale price, while also seeking assurance that the agent will be diligent in their efforts. Considering the regulatory framework governing property agents in the NT, which type of listing agreement best balances the vendor's objectives with the agent's professional commitment and commission security? Option A. An exclusive agency listing agreement where the agent is entitled to a commission unless the vendor sells the property themselves. Option B. An open listing agreement where the agent is not exclusive and may have to compete with other agents and the vendor for a commission. Option C. A net listing agreement, where the agent receives any amount over a predetermined net price set by the vendor. Option D. An exclusive right to sell listing agreement, where the agent is entitled to a commission regardless of who introduces the buyer. The correct answer is D. An exclusive right to sell listing agreement, where the agent is entitled to a commission regardless of who introduces the buyer. Explanation. Scenario analysis. This scenario presents a common professional challenge for real estate agents in the Northern Territory, NT, concerning the selection of an appropriate listing agreement. The challenge lies in balancing the vendor's desire for maximum exposure and potential sale price with the agent's need for a secure commission and clear contractual terms. Misunderstanding or misapplying the different types of listing agreements can lead to disputes, ethical breaches, and potential legal ramifications under NT property law. Careful judgment is required to ensure the chosen agreement aligns with the vendor's objectives and the agent's professional obligations. Correct approach analysis. The most appropriate approach in this scenario is to recommend an exclusive right to sell listing agreement. This agreement provides the agent with the highest level of security and incentive, as they are entitled to a commission regardless of who introduces the buyer and effects the sale. This aligns with the vendor's objective of achieving the best possible price through maximum marketing efforts, as the agent is motivated to invest resources without fear of losing their commission to another agent or the vendor selling independently. Under the Northern Territory's Property Agents Administration Act 2008 and associated regulations, clear contractual terms are paramount, and an exclusive right to sell provides the most unambiguous framework for commission entitlement, thereby minimizing potential disputes. It ensures the agent's efforts are rewarded and encourages comprehensive marketing strategies that benefit the vendor. Incorrect approaches analysis. Recommending an exclusive agency agreement would be professionally unsound. While it grants the agent exclusivity, it allows the vendor to sell the property themselves without owing a commission. This creates a significant risk for the agent, as they may expend considerable time and resources on marketing only to have the sale concluded by the vendor, negating their commission. This approach does not fully align with the vendor's stated desire for maximum exposure and price, as it introduces a loophole that could undermine the agent's efforts. Suggesting an open listing agreement is also professionally unacceptable in this context. An open listing means the agent is not exclusive and may have to compete with multiple other agents, and even the vendor, to secure a commission. This significantly diminishes the agent's motivation to invest heavily in marketing and promotion, as their chances of earning a commission are diluted. It fails to provide the vendor with the dedicated and focused marketing campaign they seek, and is contrary to the principle of ensuring the agent's efforts are appropriately incentivized and protected under NT property regulations. Professional reasoning. Professionals should adopt a client-centric decision-making process. This involves thoroughly understanding the vendor's objectives, risk tolerance, and desired level of marketing effort. They must then match these objectives with the contractual frameworks available under NT law, considering the implications of each listing agreement type on commission security, marketing investment, and potential for disputes. A transparent discussion with the vendor about the pros and cons of each agreement, with a clear recommendation based on their stated goals and the agent's capacity to deliver, is essential for ethical and effective practice. Question 13. The evaluation methodology shows a need to assess the compliance of a proposed real estate investment trust rate, operating in the Northern Territory, Australia, with relevant regulatory requirements concerning its offering documents and operational structure. Which of the following approaches best ensures adherence to Australian financial services law and investor protection principles. Option A. A comprehensive review of the rate offering documents and operational framework against the Corporations Act 2001, CTH, and relevant ASIC regulatory guides, ensuring all disclosures are accurate, clear, and not misleading, and that the structure meets the criteria for a managed investment scheme. Option B. Prioritizing the potential for high investor returns and the ease of marketing the investment opportunity, with a secondary consideration for disclosure requirements. Option C. Relying on general real estate investment industry standards and the perceived marketability of the underlying Northern Territory properties to gauge the suitability of the rate structure. Option D. Focusing solely on Northern Territory land use and property development laws, assuming these are the primary regulatory considerations for the rate offering. Correct answer is A. A comprehensive review of the rate offering documents and operational framework against the Corporations Act 2001, CTH, and relevant ASIC regulatory guides, ensuring all disclosures are accurate, clear, and not misleading, and that the structure meets the criteria for a managed investment scheme. Explanation. The evaluation methodology shows a critical need for understanding the regulatory landscape governing real estate investment trusts, REIT, in the Northern Territory, NT, Australia. This scenario is professionally challenging because it requires navigating specific NT legislation and ASIC guidelines concerning disclosure, investor protection, and the operational requirements for entities seeking to qualify as REIT, particularly when dealing with potential investors who may have varying levels of financial sophistication. Careful judgment is required to ensure compliance and prevent misrepresentation. The correct approach involves a thorough review of the rate offering documents and operational structure against the Corporations Act 2001, CTH, and relevant ASIC regulatory guides, specifically those pertaining to disclosure and managed investment schemes, as well as any NT-specific property development or land use regulations that might indirectly impact rate operations. This includes verifying that the rate's stated investment strategy, asset diversification, income distribution policies, and governance structures align with the requirements for registration and operation as a managed investment scheme, and that all disclosures to potential investors are accurate, clear, and not misleading, as mandated by Chapter 6D of the Corporations Act 2001, CTH, and ASIC RG 168. This ensures investor confidence and adherence to Australian financial services law. An incorrect approach would be to rely solely on general industry best practices for real estate investment without verifying specific NT and Commonwealth legislative compliance. This fails to address the legal obligations under the Corporations Act 2001, CTH, and ASIC guidelines, potentially exposing investors to risks not adequately disclosed and the entity to regulatory penalties. Another incorrect approach would be to assume that because the underlying assets are in the Northern Territory, only NT land law applies. This overlooks the fact that the offering and operation of a rate as a managed investment scheme fall under Commonwealth legislation, primarily the Corporations Act 2001, CTH, and are regulated by ASIC. Neglecting this crucial federal regulatory layer is a significant compliance failure. A further incorrect approach would be to focus exclusively on the potential returns and marketability of the properties without scrutinizing the rate compliance with disclosure obligations regarding fees, risks, and the liquidity of investments. This prioritizes commercial interests over investor protection, a fundamental ethical and regulatory failing under Australian financial services law. Professionals should adopt a systematic decision-making process that begins with identifying the relevant regulatory frameworks, Commonwealth and NT, where applicable. This involves consulting the Corporations Act 2001, CTH, ASIC regulatory guides, and any specific NT legislation impacting property investment. The next step is to meticulously compare the rate proposed structure, operations, and disclosure documents against these legal requirements. Any discrepancies or ambiguities should be clarified through legal counsel or direct consultation with ASIC. Finally, a commitment to transparency and investor protection should guide all decisions, ensuring that all information provided to potential investors is accurate, complete, and compliant with all applicable laws. Question 14. The monitoring system demonstrates that a real estate agent in the Northern Territory, NT, Australia, has facilitated a client's property purchase by recommending a mortgage broker who offers a referral fee to the agent. The client has proceeded with the mortgage broker's services. What is the most appropriate course of action for the agent to ensure regulatory compliance and uphold professional ethics in this situation? Option A. Immediately provide the client with a written disclosure detailing the referral fee arrangement with the mortgage broker and reiterate that the client is free to choose any lender or broker. Option B. Advise the client that the referral fee is standard practice and that the recommended broker is the best option due to their efficiency. Option C. Inform the client about the referral fee only after the mortgage has been finalized and the loan settlement has occurred. Option D. Assume the client understands the agent's potential financial benefit from the referral and proceed without further disclosure. The correct answer is A. Immediately provide the client with a written disclosure detailing the referral fee arrangement with the mortgage broker and reiterate that the client is free to choose any lender or broker. Explanation. The monitoring system demonstrates a potential breach of regulatory requirements concerning real estate financing in the Northern Territory, NT, Australia. This scenario is professionally challenging because it requires a real estate agent to navigate the complexities of disclosure obligations and potential conflicts of interest when dealing with a client's financing arrangements, all within the specific legislative framework of the NT. Careful judgment is required to ensure compliance and maintain professional integrity. The best approach involves proactively identifying and disclosing potential conflicts of interest related to financing options to the client. This entails clearly informing the client about any commission or referral fees received from lenders or financiers, and ensuring the client understands that the agent's primary duty is to their best interests, not to a particular lender. This aligns with the principles of the Agents Licensing Act 1979, NT, and the Australian consumer law, which mandate transparency and prohibit misleading or deceptive conduct. By prioritizing full disclosure, the agent upholds their fiduciary duty to the client and avoids any appearance of impropriety. An incorrect approach involves recommending a specific lender solely based on the referral fee structure without fully disclosing this arrangement to the client. This failure to disclose a material fact, such as the financial incentive for the recommendation, constitutes misleading conduct under the Australian consumer law and a breach of the agent's duty of good faith and disclosure under the Agents Licensing Act 1979, NT. Another incorrect approach is to assume the client is aware of the agent's potential financial benefit from recommending a particular lender. Ignorance or assumption of client knowledge does not absolve the agent of their disclosure obligations. This oversight can lead to a perception of undue influence or a conflict of interest that has not been properly managed, violating the trust inherent in the agent-client relationship and NT real estate regulations. A further incorrect approach is to only disclose the referral fee after the client has committed to a loan. Disclosure must be made at a point where the client can genuinely use the information to make an informed decision. Late disclosure negates the purpose of transparency and can be seen as an attempt to conceal a conflict of interest, undermining the client's autonomy and the agent's professional standing. Professionals should adopt a decision-making framework that prioritizes client interests and regulatory compliance. This involves a proactive approach to identifying potential conflicts of interest, understanding all relevant disclosure obligations under NT legislation, and communicating transparently and comprehensively with clients at every stage of the transaction. When in doubt, seeking clarification from regulatory bodies or legal counsel is a prudent step. Question 15. Risk assessment procedures indicate a real estate agent in the Northern Territory, NT, is reviewing applications for a rental property. One applicant appears to be a young student with limited employment history, while another is a mature individual with a stable job and excellent rental references. The agent feels the mature individual would be a more responsible tenant and is tempted to prioritize their application based on this intuition. What is the most appropriate and legally compliant approach for the agent to take in this situation? Option A. Prioritize the application of the mature individual because their stable employment and references suggest they are likely to be a more responsible tenant based on the agent's professional judgment. Option B. Focus on the applicant's perceived lifestyle and social compatibility with the property and neighborhood, rather than solely on financial and rental history. Option C. Objectively assess both applicants based on verifiable criteria such as rental history, proof of income, and references, ensuring no discriminatory factors influence the decision. Option D. Inform the student applicant that their limited employment history might make it difficult to secure the tenancy and suggest they find a guarantor. The correct answer is C. Objectively assess both applicants based on verifiable criteria such as rental history, proof of income, and references, ensuring no discriminatory factors influence the decision. Explanation. Scenario analysis. This scenario presents a common ethical dilemma for real estate agents in the Northern Territory (NT) when screening prospective tenants. The challenge lies in balancing the landlord's need for a reliable tenant with the legal and ethical obligations to avoid discrimination and ensure fair housing practices. Agents must navigate potential biases, both conscious and unconscious, while adhering to the specific provisions of NT legislation. The pressure to secure a tenant quickly can sometimes lead to shortcuts that compromise these principles. Correct approach analysis. The best professional practice involves a systematic and objective evaluation of all applicants based on predetermined, non-discriminatory criteria. This approach prioritizes gathering verifiable information directly relevant to the applicant's ability to meet the tenancy obligations, such as rental history, references, and proof of income. It strictly avoids any questions or considerations that could lead to discrimination based on protected attributes under NT law, such as race, age, or family status. This aligns with the principles of the Residential Tenancies Act 1999, NT, and the general duty of care and ethical conduct expected of real estate agents in the NT. By focusing solely on financial capacity and past tenancy performance, the agent ensures a fair and legal selection process. Incorrect approaches analysis. One incorrect approach involves making assumptions about an applicant's reliability based on their perceived lifestyle or background, such as their employment status or family situation, without seeking objective evidence. This can lead to indirect discrimination, which is prohibited under NT anti-discrimination legislation. For example, assuming a single parent is less likely to pay rent on time without any supporting evidence from their rental history or financial capacity is discriminatory. Another unacceptable approach is to prioritize applicants who appear to be a better fit, socially or personally, even if other applicants meet the objective criteria. This subjective judgment opens the door to unconscious bias and can result in unfair selection, potentially violating the spirit and letter of fair housing laws in the NT. The agent's personal preferences should never influence the selection process. A further flawed approach is to request information that is not directly relevant to the tenancy agreement or the applicant's ability to fulfill their obligations, such as details about their personal relationships or future family plans. This can be intrusive and may inadvertently lead to discriminatory decisions. The focus must remain on the applicant's capacity to pay rent, maintain the property, and adhere to the terms of the lease. Professional reasoning. Professionals in the NT real estate industry must adopt a decision-making framework that prioritizes legal compliance and ethical conduct. This involves establishing clear, objective screening criteria before reviewing applications, ensuring these criteria are applied consistently to all applicants, and documenting the entire process. Agents should be trained to recognize and mitigate personal biases. When in doubt, seeking advice from legal counsel or industry bodies regarding compliance with the Residential Tenancies Act 1999, NT, and anti-discrimination laws is crucial. The ultimate goal is to select the most suitable tenant based on their proven ability to meet tenancy obligations, without resorting to discriminatory practices. Question 16. Strategic planning requires a financial advisor in the Northern Territory, NT, to consider the implications of recommending private mortgage insurance, PMI, to a client purchasing a property. The advisor knows that recommending a specific PMI product will result in a significantly higher commission compared to other available options, and the client has expressed some concern about the additional cost of PMI. What is the most ethically and regulatorily sound approach for the advisor to take? Option A. Recommend the PMI product that offers the highest commission, highlighting only its perceived benefits and downplaying the associated costs and any potential drawbacks to maximize personal earnings. Option B. Proceed with recommending the PMI product that generates the highest commission, assuming the client's concern about cost is minor and that the commission structure is standard industry practice, without detailed disclosure of the commission itself. Option C. Advise the client against taking PMI altogether, regardless of its potential benefits, to avoid any perceived conflict of interest, even if it means the client misses out on valuable protection. Option D. Conduct a thorough assessment of the client's financial situation, risk tolerance, and property purchase goals to determine if PMI is genuinely suitable and beneficial for them. If it is, fully disclose all associated costs, benefits, and commission structures, ensuring the client understands the product and its alternatives before proceeding. The correct answer is D. Conduct a thorough assessment of the client's financial situation, risk tolerance, and property purchase goals to determine if PMI is genuinely suitable and beneficial for them. If it is, fully disclose all associated costs, benefits, and commission structures, ensuring the client understands the product and its alternatives before proceeding. Explanation. Strategic planning requires careful consideration of ethical obligations and regulatory compliance, particularly when dealing with financial products like private mortgage insurance, PMI, in the Northern Territory, NT of Australia. This scenario is professionally challenging because it pits the potential for increased commission against the client's best interests and the integrity of the advice provided. A financial advisor must navigate the complexities of disclosure, suitability, and potential conflicts of interest to ensure they are acting in a fiduciary capacity. The best professional approach involves prioritizing the client's financial well-being and ensuring full transparency regarding all available options and their implications. This means thoroughly assessing the client's specific circumstances, including their risk tolerance, financial goals, and the cost-benefit analysis of PMI in their particular situation. If PMI is deemed suitable, the advisor must clearly explain its purpose, benefits, costs, and any alternatives, ensuring the client fully understands what they are agreeing to. This aligns with the ethical duty of care and the regulatory requirements under the Australian Securities and Investments Commission, ASIC, guidelines, which mandate that financial advice must be appropriate and in the client's best interests. An approach that involves recommending PMI solely because it generates a higher commission, without a thorough assessment of its suitability for the client, is ethically unsound and breaches regulatory obligations. This prioritizes the advisor's financial gain over the client's needs, constituting a conflict of interest that has not been properly managed. Furthermore, failing to disclose the commission structure associated with PMI to the client is a direct violation of disclosure requirements, undermining trust and transparency. Another unacceptable approach is to downplay the costs or potential downsides of PMI to secure the sale. This misrepresents the product and fails to provide the client with the complete information necessary for an informed decision. Such conduct erodes client confidence and can lead to significant financial detriment for the client, potentially resulting in regulatory action against the advisor. Professionals should employ a decision-making framework that begins with a comprehensive understanding of the client's needs and objectives. This is followed by a diligent research and analysis of all relevant financial products, including their costs, benefits, risks, and suitability. Any potential conflicts of interest must be identified and managed proactively through transparent disclosure, and by ensuring the client's interests always come first. The ultimate decision should be based on what is demonstrably in the client's best interests, supported by clear and documented reasoning. Question 17. The control framework reveals that a real estate agent in the Northern Territory is assisting a client who wishes to purchase a property using a government-backed loan program. The client expresses concern about meeting the specific eligibility criteria for the loan, but is eager to proceed with the purchase. The agent, wanting to secure the sale, considers advising the client that the property is definitely eligible and that they can help make it happen by submitting the application with minimal fuss, even if some documentation is not perfectly aligned with the program's strict guidelines. What is the most ethically and legally sound approach for the agent to take in this situation? Option A. Advise the client that they must thoroughly review the specific eligibility requirements of the government-backed loan program and ensure all documentation is accurate and complete before submission, guiding them to seek professional advice if needed, and only proceeding with the application once eligibility is confirmed. Option B. Focus solely on securing the sale by encouraging the client to proceed with the purchase regardless of their eligibility for the government-backed loan, advising them to worry about the loan details later. Option C. Suggest to the client that the agent can expedite the loan approval by submitting slightly altered or incomplete documentation, implying they have a way to bypass some of the program's standard checks. Option D. Assure the client that the property is guaranteed to be eligible for the government-backed loan and that the agent will handle the application process smoothly, downplaying the importance of strict adherence to all criteria. The correct answer is A. Advise the client that they must thoroughly review the specific eligibility requirements of the government-backed loan program and ensure all documentation is accurate and complete before submission, guiding them to seek professional advice if needed, and only proceeding with the application once eligibility is confirmed. Explanation. The control framework reveals a common ethical dilemma faced by real estate professionals in the Northern Territory, NT, when dealing with government-backed loan programs. This scenario is professionally challenging because it requires balancing the client's immediate financial needs and desires with the strict eligibility criteria and disclosure obligations mandated by NT legislation and the specific terms of government-backed loan schemes. Misrepresenting a client's situation to secure a loan, even with good intentions, can lead to severe legal and ethical repercussions for the agent and significant financial harm to the client. Careful judgment is required to navigate these complexities ethically and legally. The best professional approach involves diligently verifying the client's eligibility for the specific government-backed loan program in the Northern Territory and providing accurate, transparent advice. This means thoroughly understanding the criteria for programs like those potentially offered or supported by NT government initiatives, though FHA, VA, and USDA are U.S.-specific. The principle applies to any NT equivalent or federally supported program accessible in NT. The agent must guide the client through the application process honestly, ensuring all information provided is truthful and supported by documentation. This aligns with the NT's consumer protection laws, which mandate fair dealing and prohibit misleading or deceptive conduct. Ethically, it upholds the agent's duty of care and loyalty to the client, ensuring they are not misled into a financial commitment they cannot sustain or are ineligible for. An incorrect approach would be to advise the client that their property is guaranteed to qualify for a government-backed loan without a thorough assessment of the specific program's requirements and the property's compliance. This misrepresents the certainty of loan approval and potentially breaches NT consumer law by making unsubstantiated claims. It also fails to uphold the agent's duty to provide accurate information, risking the client's financial well-being and the agent's professional standing. Another incorrect approach involves suggesting that the agent can expedite or influence the approval of a government-backed loan by submitting incomplete or slightly altered documentation. This is unethical and illegal. Government-backed loan programs have stringent approval processes designed to protect public funds and ensure borrower responsibility. Any attempt to circumvent these processes through misrepresentation or falsification of information constitutes fraud and violates NT's anti-fraud legislation, as well as the ethical codes governing real estate professionals. A further incorrect approach would be to downplay the importance of the client meeting all eligibility criteria for the government-backed loan, focusing solely on securing the sale. This prioritizes the agent's commission over the client's best interests and financial security. It ignores the fundamental responsibility of an agent to ensure a transaction is viable and compliant with all relevant laws and program guidelines, potentially leading to loan rejection, financial distress for the client, and disciplinary action against the agent under NT's property services regulations. Professionals should adopt a decision-making framework that prioritizes transparency, due diligence, and adherence to regulatory requirements. This involves 1. Understanding the client's goals and financial situation. 2. Thoroughly researching and understanding the specific government-backed loan programs available and their eligibility criteria relevant to the Northern Territory. 3. Conducting a preliminary assessment of the client's and property's eligibility. 4. Providing honest and accurate advice, clearly outlining potential challenges and requirements. 5. Guiding the client through the application process with integrity, ensuring all submitted information is truthful and verifiable. 6. Disclosing any potential conflicts of interest. 7. Seeking clarification from loan providers or regulatory bodies when in doubt. Question 18. Cost-benefit analysis shows that a property in Darwin, Northern Territory, is being considered for sale. The vendor has expressed a desire for the highest possible price, which approach best balances the vendor's financial aspirations with the realities of the Northern Territory's real estate market and economic factors. Option A. Recommend a price well below current market comparables to ensure a rapid sale, without fully exploring the vendor's financial objectives or the potential for achieving a higher price within the NT market. Option B. Base the valuation primarily on the property's unique architectural features and potential for future capital growth, while downplaying the impact of current economic conditions and recent sales data in the Northern Territory. Option C. Advise the vendor to set an asking price significantly above comparable sales, based on their stated desire for the highest possible price, without extensive market data to support this premium. Option D. Conduct a thorough comparative market analysis, using recent sales data from similar properties in Darwin, factoring in current economic indicators such as local employment trends and interest rates, to recommend a price that reflects both market value and the potential for a timely sale. The correct answer is D. Conduct a thorough comparative market analysis, using recent sales data from similar properties in Darwin, factoring in current economic indicators such as local employment trends and interest rates, to recommend a price that reflects both market value and the potential for a timely sale. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a real estate agent in the Northern Territory, NT, to balance the immediate financial interests of a vendor with the broader economic implications of their pricing strategy. Overpricing can lead to a prolonged listing period, potentially damaging the property's market perception and increasing the vendor's holding costs. Underpricing, while potentially leading to a quick sale, might not achieve the vendor's desired financial outcome. Navigating these competing pressures requires a deep understanding of NT's specific real estate market dynamics and economic factors, as well as adherence to ethical obligations. Correct approach analysis. The best professional practice involves a comprehensive market analysis that considers current NT real estate market conditions, recent comparable sales, and prevailing economic factors such as interest rates, employment levels, and local development projects. This approach prioritizes providing the vendor with an informed, data-driven recommendation that balances their desire for a high sale price with the realistic market value and potential for a timely sale. This aligns with the agent's duty to act honestly and competently, as expected under NT consumer protection laws and professional conduct standards for real estate agents, ensuring the vendor makes an informed decision based on objective market realities. Incorrect approach is analysis. Recommending a price significantly above market value solely based on the vendor's stated expectations, without robust supporting data from the NT market, fails to uphold the agent's duty of care and competence. This approach risks misleading the vendor and can lead to prolonged market exposure, potentially diminishing the property's appeal, and ultimately resulting in a lower sale price than could have been achieved with a more realistic initial valuation. It also breaches ethical obligations to provide honest and transparent advice. Suggesting a price significantly below market value to guarantee a quick sale, without thoroughly exploring the vendor's financial goals and the potential for achieving a higher price through strategic marketing within the NT context, is also professionally unacceptable. This approach prioritizes the agent's convenience or potential for a swift commission over the vendor's best financial interests and may not be justifiable by current NT market conditions or economic indicators. Focusing exclusively on the property's unique features and potential for future appreciation, while disregarding current NT market comparables and economic headwinds, is an incomplete valuation. While future potential is a factor, the immediate sale price must be grounded in present market realities and economic conditions to be realistic and achievable for the vendor. Professional reasoning. Professionals should adopt a systematic approach. First, gather all relevant data on the property and its recent NT market comparables. Second, analyze current NT economic indicators that might influence buyer demand and affordability. Third, engage in an open and honest discussion with the vendor, presenting the data and explaining the rationale behind the recommended price range, including the potential consequences of over- or underpricing. Fourth, collaboratively determine a pricing strategy that aligns with the vendor's objectives and the objective market assessment, ensuring transparency and informed consent. Question 19. During the evaluation of potential real estate investments in Darwin, Northern Territory, For a client seeking to diversify their portfolio, which comparative analysis approach would best serve to provide an objective and informed recommendation? Option A. Selecting only the single most recently sold comparable property in the broader Darwin region to establish a benchmark value. Option B. Relying primarily on the asking prices of properties that align with the client's desired amenities, assuming these reflect current market sentiment. Option C. Conducting a comprehensive comparative market analysis by examining recently sold, currently listed, and expired listings of similar properties in the same or adjacent suburbs, adjusting for key differences in features and market conditions. Option D. Prioritizing properties with identical amenity lists, irrespective of their location within the Northern Territory or their sales history. The correct answer is C. Conducting a comprehensive comparative market analysis by examining recently sold, currently listed, and expired listings of similar properties in the same or adjacent suburbs, adjusting for key differences in features and market conditions. Explanation. Scenario analysis. This scenario presents a professional challenge for a real estate agent in the Northern Territory, NT, due to the inherent subjectivity in valuing investment properties and the potential for conflicts of interest. Accurately assessing the comparative value of different investment opportunities requires a thorough understanding of the NT property market, economic factors, and the specific needs and risk tolerance of the client. Failure to conduct a robust comparative analysis can lead to misinformed investment decisions by the client, potentially resulting in financial loss and damage to the agent's reputation and professional standing. The agent must navigate these complexities while adhering to the ethical and legal obligations under NT real estate legislation. Correct approach analysis. The best professional practice involves conducting a comprehensive comparative market analysis, CMA, for each potential investment property. This approach requires the agent to identify and analyze recently sold, currently listed, and expired listings of comparable properties within the same or similar NT suburbs. The analysis should consider key features such as property type, size, condition, amenities, location, and recent sales trends in the NT market. By systematically comparing these factors, the agent can derive a realistic estimated market value range for each property, providing the client with objective data to inform their investment decision. This aligns with the principles of professional conduct and the duty of care owed to clients under NT real estate regulations, which mandate providing accurate and unbiased advice. Incorrect approaches analysis. Relying solely on the asking price of a property without independent verification is professionally unacceptable. This approach fails to acknowledge that asking prices are often aspirational and may not reflect the true market value. Bypasses the essential due diligence required by NT real estate law, which expects agents to provide informed advice based on market realities, not just seller expectations. Using only the most recently sold comparable property, regardless of its specific characteristics or market relevance, is also a flawed approach. This method ignores the nuances of the NT market and the unique attributes of the subject property, potentially leading to an inaccurate valuation. NT regulations emphasize a thorough and objective assessment, which this limited comparison fails to achieve. Focusing exclusively on properties with similar amenities, even if they are in different suburbs or have significantly different sales histories, is another professionally unsound method. While amenities are important, the location and recent sales data within the immediate NT market are paramount for a reliable comparative analysis. This approach risks overemphasizing minor similarities while overlooking critical market indicators, thereby failing to meet the professional standards expected in the NT. Professional reasoning. Professionals should adopt a systematic and data-driven approach to comparative analysis. This involves 1. Understanding the client's investment objectives and risk profile. 2. Identifying a broad range of comparable properties in the relevant NT market. 3. Critically evaluating the comparability of each property based on multiple factors. 4. Adjusting for differences between the subject property and comparables. 5. Synthesizing the data to establish a realistic market value range. 6. Presenting the findings to the client in a clear, objective, and unbiased manner, empowering them to make an informed decision. This process ensures compliance with regulatory requirements and upholds ethical standards by prioritizing the client's best interests. Question 20. What factors determine the appropriate adjustment to the listing price of a property in the Northern Territory when significant environmental contamination is discovered, and how should this adjustment be calculated and communicated to potential buyers? Option A. The adjustment is determined by the seller's belief that the contamination is minor and communicated by omitting any mention of environmental issues in the sale process. Option B. The adjustment is determined by engaging qualified environmental consultants to assess the extent of contamination and estimate remediation costs, then calculating the adjusted sale price by subtracting these costs and a risk premium from the property's market value without contamination, and communicating this through comprehensive, documented disclosure to all parties. Option C. The adjustment is determined by the agent's personal opinion of the contamination's impact and communicated by a brief mention in the property listing. Option D. The adjustment is determined by the seller's desired price reduction without any independent assessment and communicated by verbally informing potential buyers of a general price decrease. The correct answer is B. The adjustment is determined by engaging qualified environmental consultants to assess the extent of contamination and estimate remediation costs, then calculating the adjusted sale price by subtracting these costs and a risk premium from the property's market value without contamination, and communicating this through comprehensive, documented disclosure to all parties. Explanation. Scenario analysis. This scenario presents a professional challenge for a real estate agent in the Northern Territory, NT, due to the intersection of environmental regulations, property valuation, and client disclosure obligations. The agent must navigate the potential impact of a contaminated site on property value and the legal requirements for transparency, balancing their fiduciary duty to the client with the public interest and regulatory compliance. Misjudging the environmental impact or failing to disclose relevant information can lead to significant legal and ethical repercussions. Correct approach analysis. The best professional approach involves a thorough, data-driven assessment of the environmental contamination's impact on the property's market value. This requires engaging qualified environmental consultants to conduct a detailed site assessment and remediation cost analysis. The agent should then use these findings to adjust the property's listing price and provide comprehensive, documented disclosure to all potential buyers. This approach aligns with the Northern Territory's environmental protection legislation, which mandates disclosure of material environmental information and upholds the agent's ethical duty to act with honesty and diligence, ensuring informed decision-making by buyers and protecting the agent from liability. The calculation of the adjusted sale price would involve determining the difference between the property's market value without contamination and its market value with the estimated remediation costs factored in, potentially using a formula like adjusted sale price equals market value, uncontaminated, estimated remediation costs, risk premium, incorrect approaches analysis. One incorrect approach is to proceed with the sale at the original, higher price without disclosing the contamination or obtaining an independent environmental assessment. This violates the Northern Territory's environmental disclosure requirements and the agent's ethical obligation to provide accurate information. It exposes the seller and agent to potential legal action from the buyer for misrepresentation and non-disclosure, and it undermines the integrity of the real estate market. Another incorrect approach is to significantly reduce the price based on a mere suspicion of contamination without any concrete evidence or professional assessment. While disclosure is important, an arbitrary price reduction without supporting data can mislead buyers about the true extent of the problem and its remediation costs, potentially devaluing the property unnecessarily and failing to meet the fiduciary duty to achieve the best possible price for the seller within legal and ethical bounds. A third incorrect approach is to rely solely on the seller's anecdotal information about past industrial use without independent verification. While the seller's information may be a starting point, it is not a substitute for a professional environmental assessment. Failing to conduct due diligence can lead to an incomplete understanding of the contamination scope and impact, resulting in inaccurate pricing and inadequate disclosure, thereby breaching regulatory and ethical standards. Professional reasoning. Professionals should adopt a systematic decision-making process. First, identify all relevant regulatory requirements, e.g., NT Environmental Protection Act, property disclosure laws. Second, assess the potential impact of the identified issue, environmental contamination, on the property's value and marketability. Third, gather objective data through qualified professionals, environmental consultants. Fourth, calculate the financial implications using appropriate methodologies, such as the formula for adjusted sale price. Fifth, ensure full and transparent disclosure to all parties involved, documenting all steps taken. Finally, consult with legal counsel if the situation presents significant legal or ethical complexities.